Afternoon, it's that time again. It's near triple digits here in Los Angeles, California, and we are the Rains Feldman Cyber Liability Litigators, and we're here with a legal update. I'm Eric Cyberson. We have Steve Geblin on my right and Scott Leswitz on my left. And guys, today we are going to be talking about copyright law. We're going to be talking about a Supreme Court case. And more specifically, we're going to be talking about, do you get your attorney's fees paid upon either winning a copyright case, or if you're the defendant and you defense the case, do you get your attorney's fees? So the case is called Kirtsaeng versus Wiley, and Wiley was a publisher of textbooks, right? And Kirtsaeng, I believe, was importing textbooks for sale in the U.S. From Thailand, and I believe they were textbooks that were, let's say, manufactured in the U.S. or produced in the U.S. and then exported to Thailand. Is that right, guys, or do we not know that?
If I recall correctly, so Kirtsaeng, there's a previous Supreme Court case that dealt more with where the books were produced and where they were sold, but if I remember correctly, they were legally produced for sale in Thailand. So the books were meant to be sold into Thailand at a lower cost than the same kind of textbook would be sold in the U.S.
They're cheaper in Thailand,
right?
Because the students in Thailand don't have as much money as the students in America. Although the students in America don't have a lot of money, they have a lot of debt. But that's another topic.
Right.
Yeah, can't do that one within 15 minutes.
Yeah, we need another one of that. So I'll toss the ball up in the air, guys. Who won? I mean, I think I know who won. Kirtsaeng won, right? But why did Kirtsaeng win?
So the previous case at the Supreme Court actually went all the way up to the Supreme Court before Kirtsaeng got a victory, saying that he could legally import these books that were fine to sell in Thailand and bring them in and sell them in the United States. Up until that point, it was sort of an undecided question before the Supreme Court whether stuff that was legally copyrighted for somewhere else could be brought into the United States. They called it gray markets. So, huge, giant, long legal battle that this student, basically from a foreign student from Thailand, said, "Oh, I can bring in books and sell them and make a couple bucks." His case goes all the way to the Supreme Court to decide this undecided issue of law. After that, he goes back down to the district court and says, "Hey, I won. It's a copyright case. There's this provision in the copyright law that says the winning party can get their attorney's fees paid for by the other side." And in the Second Circuit, there was a test that said, well, no, if there's the party resisting the winning party, so the losing party, if they had a reasonably objective case or a reason for their defense, you don't get to shift your attorney's fees to them.
So that Second Circuit Court said that Wiley had a legit case.
Yeah.
Wiley was the plaintiff. Wiley didn't want this to happen. Okay, got it. So, and so the court did not award Kirtsaeng his fees.
Right.
And then he goes back up for another visit to the Supreme Court.
He goes back up to the Supreme Court for a second time, and this time, again, the Supreme Court reverses the lower court, but this time doesn't really give Kirtsaeng a big victory. The court says, well, yes, you're right to look at whether or not the plaintiff was objectively reasonable in bringing their case, but you have to look at other factors too. So we'll send it back down. The district court can look again, but the first thing it should be looking at is whether it's objectively reasonable. It should also look and see how the parties litigated the case, whether there's any sort of reason to try and deter future litigation, if that's a reason to shift fees. But you can't use this as a but-for test. You can't use this as the only reason to give attorney's fees, but yeah, it can be the main reason why you award attorney's fees.
Which would be, just to sum up, so if it was, if the defense in this situation was objectively reasonable, he gets fees.
Well, it
Or
takes-
no? Is it the opposite? Chime in, Scott.
Well,
It's confusing, I think. I don't think it's a great opinion or provides a lot of clarity.
Yeah, so the Second Circuit said if it's reasonable, you automatically, when you're defending and you defend unsuccessfully, as long as your defense was reasonable, you automatically don't have to pay the attorney's fees.
Got it?
Now it's saying, well, even if your position was reasonable, we're still going to look at other factors, and it's possible you still might have to pay attorney's fees. So this makes the it a little bit more risky to enter into copyright litigation and
Well, it's also
potentially
not.
losing.
That's also not necessarily if you win or lose. Now it's how you win or lose.
Yeah.
Is what I'm hearing.
Yes.
I mean, how did you conduct your litigation? That to me seems very confusing. We're litigators. You're often in a case, and you know it can be difficult sometimes to. Sometimes you have a difficult dance partner in opposing counsel, and you get into very nasty fights, so to speak.
Right.
It's just a fact of the matter. And sometimes, even if you're correct and righteous, you end up looking poor to the court as well. We've all been in those situations. That can be very challenging, I think.
Yeah, I think it's
Based on this
important now to have good, reasonable attorneys who understand how to litigate these cases so you don't fall into these types of pitfalls. It's not just a matter of picking and choosing whether or not to litigate or defend. You really need to understand how to litigate or defend.
Steve, you think that this may, maybe I'm putting words in your mouth, but do you think this may, who does this harm? Is this a blow to copyright trolls, people who are overly aggressive
Yeah,
enforcing their copyrights?
I think some of the people that this would affect would be, yeah, someone that we would say would be a troll. So somebody that's making unreasonable demands in a lot of cases, even if they're reasonable in some of their cases, if they're unreasonable across the board, making lots of cases where most of them aren't really good cases, those people aren't likely to get their attorney's fees, or might even get them awarded against them in any case. That was one of the examples that the Supreme Court specifically called out.
One issue that pops into my mind, do we know if the court awarding fees can, in making its determination of these various factors, particularly with how the litigation is conducted, can the court look at, you know, the settlement demands and sort of the settlement dealings? Because a lot of times, what I'm getting at is a lot of times in copyright cases, the attorney's fees provide a lot of the value to the plaintiff or the defendant. They can drive settlement negotiations. Oftentimes, copyright cases are not big damages cases. Now, sometimes they are, but that's why you have the statutory damages provisions. We have personally seen this dynamic. It's not the exact same case, but in a fairly large, well-known trademark case that we were involved in, when the attorney's fees outstrip the actual damages by a factor of, I don't know, 50 or 100. So, you know, I'm wondering if a court can look at that. Does the opinion talk about that at all?
The opinion doesn't address that. That comes up in sort of a related kind of litigation when parties make what are known as, in federal litigation, is Rule 68, offers to settle. So those are basically a special kind of settlement offer saying, hey, I'll settle right now for this amount. And you can go get your court judgment. And those can be used in determining attorney's fees awards, especially under the Copyright Act, what attorney's fees are reasonable. So those, I think, would play into this kind of analysis when you're looking at the factor about the reasonableness of the litigation. So if a party keeps going on with the litigation, incurs a lot of fees after that point, they're not going to get them.
I think, though, that, I mean, unless the Supreme Court really makes a sea change in the law or there's a change to the Federal Rules of Civil Procedure, I mean, the general rule is that any type of settlement negotiations and communications are privileged, and I can't see that really being changed and becoming a factor in a court's analysis, since those discussions are essentially confidential.
Well,
Maybe officially no, but, you know, we know that, I mean, listen, the way
Yeah.
things play out a lot of times in federal court is, you know, you sometimes get a settlement judge, who oftentimes is a magistrate. And, you know, I'm not here to disparage judges. I think they do a great job, but I think, you know, they have parking spaces next to each other also, and they're human beings also. And so I think maybe there's a potential for that to happen. Their clerks talk to each other. So, you know, so let's wrap it up. I suppose the message is this is a Supreme Court case. We're in California. It would apply to our cases here in the Ninth Circuit. It would apply everywhere. And I think it brings a certain level of uncertainty to the copyright litigation dynamic and who will obtain fees and who won't. But we'll see how it plays out. That's the Rains Feldman Cyber Liability team. Thanks for joining us.